Good evening. My name is Phil Schomber. I'm the adult programmer here at Hedberg. I want to thank everyone for joining us for tonight's Renters' Rights program. Before I introduce our speakers, I want to hand it over to Mary Bulow with the League of Women Voters, which is co-sponsoring tonight's program.
Okay, thank you all for coming. I am Mary Bulow with the Janesville League of Women Voters. The League of Women Voters is a nonprofit political organization that encourages informed and active participation in government. League members study a wide range of issues to see where we might promote better policies and outcomes in our community. And housing is one of those issues. For many people, housing means renting a place to live. We're here tonight to learn about the rights and responsibilities of tenants and landlords, what resources are available if problems arise in rental housing. And I want to extend our thanks to our presenters tonight and to the Hedberg Public Library for hosting this program.
Thanks, Mary. Now it's my pleasure to introduce our speakers tonight, Jeffrey Kersten and Matthew White. Jeff is with the Department of Consumer Protection, and he is going to discuss the respective rights and responsibilities of landlords and tenants and share some helpful resources. And Matt is with the Wisconsin Equal Rights Division, and he's going to discuss the different prohibitions against housing discrimination and also talk about what you can do if you feel like your rights have been violated in that area. So with that, let me turn it over to Jeff to get us started.
All right, my mic is on. Hey, thanks so much for joining us tonight. My name is Jeff Kersten. I work for the State of Wisconsin Bureau of Consumer Protection, and we're here to talk about landlord-tenant rights. A little background about myself. I was a police officer for about 13 years, so I've seen a lot of landlord-tenant issues from the law enforcement side of things. I was an investigator for the Bureau of Consumer Protection for about a year before taking my current position. So I've seen firsthand how we at the state mediate and investigate these complaints and help out consumers when they have issues. So tonight, I just want to give you a little overview of what we do. We're the state's premier consumer protection agency. We regulate about 70 different laws. So if there's a transaction between a consumer and a business, there's probably a law or a code out there that we regulate that would give us authority to look into that transaction. And that's exactly what a landlord-tenant relationship is. That's a business-consumer transaction. We have the authority through both Wisconsin state statutes and administrative code to investigate these types of complaints. Just kind of break down our bureau into these 5 or 6 parts. We have a consumer protection hotline Monday through Friday that's staffed 7:45 to 4:30. The 1-800 number that's at the end of my presentation, you can call that. You get a live person. It's a great resource to ask questions. We can send out information through email, fax, regular mail, or we can walk you through the process of how to file a complaint with us right online. And then there's the outreach and education. That would be me doing programs like this. We're going to talk a little bit more about mediation later. All of our complaints start in our mediation area. So landlord-tenant complaints, that's where it's going to start. The more egregious violations move down to our investigations area, where we have the authority to forward up reports right to a district attorney's office or Department of Justice for charging decisions. You can see the top 5 consumer complaints from 2020. I've now just recently seen the 2021 numbers, and it's pretty much the same. Landlord-tenant right up there. Only second to scam phone calls and identity theft, which we're all sick and tired of, right? We have other presentations where we talk about that more in detail, but a lot of landlord-tenant complaints. All right, so there's 2 main laws that I want to talk about. State Statute 704, which is the all-encompassing law that regulates landlord-tenant relationships. It's about 18 pages long. We at the Bureau of Consumer Protection do not have authority over that law. When something goes to the courts, so an eviction process or one party sues another party, 704 is what the judges and the lawyers are going to be dealing with in those types of situations. Derived from 704 is ATCP, which just stands for Agriculture, Trade, and Consumer Protection Code 134. It's about 5.5, 6 pages long, so quite a bit smaller than 704. 134 is what we have authority over. And I'll give you some examples here coming up. So really can't talk about landlord-tenant without talking about leases, right? So rental agreements. These can both be written or verbal. I would say normally you see that they're written down. If they are written down, a copy has to be provided to the tenant. But verbal agreements are allowed. You could just make an agreement to rent a room in your friend's house and $500 a month, and it's just a verbal agreement between the two of you. And that's fine, but that actually then makes that a landlord-tenant relationship, and then there's certain laws that have to be followed during those types of transactions. And then also under this particular law, if money is paid down by the tenant in cash, receipts have to be provided. Whether the tenant asks for the receipts or not, the landlord has to provide receipts for cash payments. Not the case when paid by check or some other means, but unless the tenant requests it. All right, leases. Two big things with residential leases. We have the year-long residential lease, or we have what's called a month-to-month lease. And there's kind of pluses and minuses to both. It depends on your situation, depends on as a tenant what you're looking for, it depends on a landlord what you're looking for. Just talking some general terms here, a year-long lease, it's a contract for a year, can't be changed during that year unless it's mutually agreed upon. So rent can't go up or a change in rent unless it's agreed upon. Generally, it's about a 60-day notice at the end of the lease, whether the landlord's going to renew that or not. So the tenant has plenty of time to make those decisions of what's going to take place. Most leases, year-long leases at the end, sometimes they just turn into month-to-month agreements, but not always. So you want to read the lease. Sometimes at the end of a year-long lease, that's it. That's just the end, and it's expected that the tenant is going to vacate the premises. And then we have the month-to-month leases. This is a little bit more volatile, if you will. Changes can be made to this agreement from either party and with as little as 28-day notice. So what is today, March 8th? So if a landlord was to give notice today that rent is going to go up, well, wouldn't be able to raise rent for April 1st because that's less than 28 days before April 1st. But rent would be able to go up for May 1st. But also, that agreement can just be ended. Landlord could give notice that not going to renew, or the tenant could give notice that they're not going to renew and they're going to move out at the end of April. So a little bit more volatile, but it also allows people more flexibility. Some things have to be disclosed before entering into a lease agreement. Landlord has to disclose who the authorized agents are, pretty straightforward, who rent has to be paid to, has to disclose code violations, habitability problems. This is one that a lot of people are familiar with. There's ATCP 134 where if a room is not able to maintain 67 degrees, it's really specific how you have to measure from floor to ceiling and wall to wall. If the heating facility, the furnace is not able to maintain 67 degrees, that has to be disclosed to the tenant before entering into that lease agreement. And then utility charges. See a lot of cases where the tenant didn't know whether the utility, thought utility charges were included, but then later found out that they were a separate bill. So you want to know that right up front. The landlord should be disclosing that of whether that's included in the rent or not. Earnest money deposits. So now this isn't security deposits, that's coming up next. This is money paid down during the application process. So landlord has about 3 business days to decide whether they're going to accept a rental application or not. Basically, if the landlord denies the application or the tenant withdraws the application before the landlord has accepted it, the tenant would get their earnest money back. But there is that unique situation where the landlord could accept the rental agreement and then the tenant withdraws their application. In that situation, the landlord may be able to keep that earnest money. Don't really see as many problems with that. We get a lot more complaints about security deposits. Most tenants at the end of their lease agreements are looking for their security deposits back. So there's some things that tenants can do to help them out. During the check-in process, when moving in, do a walkthrough with the landlord, document any damage that's in the apartment. Tenants can request what has been withheld from previous tenants' security deposits so that we can see whether the landlord is withholding for the same damage over and over again, or is it new damage, things like that. And then forwarding addresses. The way the law reads is that the landlord has to return the security deposit within 21 days of the tenant vacating the apartment to the last known address. Well, if the last known address is the apartment and the tenant never updated that information with the landlord, landlord could be following the law and trying to return that security deposit, but it's not going to get back to the tenant. So tenants can help themselves out by letting the landlord know what their forwarding address is. Repairs, another area that we get a lot of complaints in. Repairs get tricky. There's lots of different types of repairs. What we specifically have authority over at the Bureau of Consumer Protection is promises to repair before the rental agreement is entered into. So you're doing a walkthrough with the landlord and you see a hole in the wall, and the landlord says, "Don't worry about that, I'll fix that before you move in." That's very specific that we have authority over that. Those promises to repair have to be written in writing, has to have start and end dates, and we have the authority to make sure that the landlord follows through on those types of repairs. Repairs that need to take place once the tenant has occupied the apartment get a little bit more tricky. So whether it's my agency, Bureau of Consumer Protection, whether it's a local building inspector, or building inspectors from the Department of Safety and Professional Services, commercial building inspectors, between the three of us, one of us can probably handle that complaint. Now, we're a mediation agency, and we'll try to mediate those complaints, but some of those become a little bit more difficult after the tenant has moved in. All right, and this is just a laundry list of a number of things that just cannot be in a rental agreement. If this language is in a lease, it can actually make the entire lease null and void. So you don't see it very often, but every once in a while, one of these things will pop up. Cannot increase rent just because the tenant calls for emergency services or law enforcement. Unlawful eviction procedures. The only way a landlord can evict a tenant is to go through the courts, the small claims court for the county that the apartment is located in. Acceleration of rent, requiring payments of attorney's fees. Again, if this language is in a lease, it can actually make the entire lease null and void. And so if that language is in a lease, that would be something that we would like to take a look at. And then some prohibited practices. There's a whole list here of things that the landlord cannot do. Obviously can't advertise or rent condemned premises. Unauthorized entry. This is one that most people are familiar with, where the landlord has to give a 12 or 24-hour notice before coming in to do inspections of the apartment, with the exception of emergency repairs. If that's happening and it's against the tenant's will, that would be something that we can handle that complaint. Automatic lease renewal. This is that unique situation that pops up where wintertime in Wisconsin, if there's a clause in the lease that you can't move out in the winter, but the year-long lease is ending in the winter, and then it kind of just turns into this automatic lease renewal, that would be something that we could look into. And then just unauthorized late fees and retaliatory self-help evictions. Again, the only way a landlord can evict a tenant is to go through the courts. Cannot turn off the heat, cannot change the locks, anything like that. That's something that we could definitely look into. And then just the catch-all misrepresentations. We have authority over state statute 100.18, which is misrepresentation. So if the landlord says anything that is intentionally misleading or untrue, that may be something that we could look into. Oops. All right, so even though we don't have authority over 704, wouldn't be a good landlord-tenant presentation if we didn't talk a little bit about the eviction process, right? So again, we don't have anything to do with this. This goes through the courts, but generally kind of how it works is, let's look at the situation where a tenant's behind on rent. So usually what happens is the landlord would issue a 5-day right to cure. The tenant has 5 days to catch up on rent. And if they do, great. If they don't, the next step for the landlord would be to file eviction in the small claims court for, in this case, Rock County, and get a court date, and they would issue the tenant a 14-day eviction notice. And then it goes in front of a judge. And we don't have anything to do with that. We're not a higher power of authority than a judge. We cannot, if a judge has already ruled on a case, filing a complaint with us, we're not going to be able to reverse that, anything like that. Now we are an open record state, so if a tenant already has a complaint with us, they can request all those documents and they can take them to court with them and use those however they like. All right, actually if you remember 2 slides ago, there was one of the prohibited regulations of a landlord is failure to deliver the premises. So let's talk about 2 situations here where a tenant either breaks a lease early or is what the law considers a holdover. So year-long lease, 6 months in, and it's the middle of winter and the tenant is tired of living in Wisconsin where it's negative 30 degrees and wants to move to Florida. And the landlord won't let him out of the lease. And the tenant just says, forget it, I'm moving to Florida. So they break that lease. The landlord is actually able to continue to charge rent each month for the remainder of that contract. But they have to do something called mitigating damages, which basically means they have to try to re-rent the apartment. If they re-rent the apartment, they no longer can charge that previous tenant. They can't be accepting rent from 2 different parties. But if that apartment goes empty for the remainder of that lease, the landlord can continue to charge rent even though the tenant is now living down in Florida. Now, what about the opposite situation where the tenant is supposed to be out of the apartment? Proper notice has been given. It's either the end of that year-long lease or a 28-day notice in a month-to-month lease. And the tenant is supposed to leave, but they don't. They just don't physically leave, and they're still in that apartment. The only person that can forcibly evict somebody from an apartment would be the sheriff's department with a lawful order from the courts. So the way the law reads in this situation, because again, remember, it's a violation for that landlord to now not deliver that apartment to the next renter that's in line. That the way the law reads, the landlord can recover double damages, or basically twice the rent prorated for each day that that tenant stays in the apartment after they're supposed to be out, without even having to go to court. So you can see that's pretty strong language in law that for double damages without even having to go to court. And obviously you can see what a bad situation that is, because now somebody else is trying to move in, the previous people are not out. It's just not a good situation. All right, and then I just want to talk a little bit about our complaint handling process. When we receive a complaint, we will get that assigned to one of our mediators within just a matter of a day or 2. That mediator will review it, look for violations of state law or administrative code that we have authority over. And then our process is that even whether we find violations we have authority over, or even if we don't, we will still take a copy of that complaint, send it off to the business, or in this case, the landlord, with a letter from us on State of Wisconsin letterhead that detail any potential violations that we see. And then we give the landlord 2 weeks to get back to us with what they're going to do in response to that complaint. So I want to be upfront with everybody right away. Our processes are not fast. So if a tenant was facing eviction next week or something, it's filing a complaint with us is not going to get a really fast response, but we certainly will look into these situations. Like I said, even if there's no potential violations, we'll still send that off to the landlord. We'll try to mediate that. We are a mediation agency. We don't take sides. Even though we only field complaints from consumers, we don't take the side of the consumer. We don't take the side of the business. We're just here to look at that complaint, make sure that both sides are following the laws and trying to eliminate that deception and unfair business practices in the marketplace. As I mentioned earlier, the more egregious violations can make it down to our investigations department. We can, forward up reports to the district attorney's office for violations of these laws that we have authority over. Doesn't happen very often with landlord-tenant, but it does happen. And then before somebody files a complaint with us, often we just, ask that you, communicate, try to talk to your landlord. A lot of times these are just situations where it's a misunderstanding, and if both parties read the lease, the language in the lease will clear things up. But just know that we're here, that if communication breaks down and the landlord is not listening to you and you feel that you've been wronged, Bureau of Consumer Protection is here to help you out. File a complaint with us. With landlord-tenant complaints, we always want to see a copy of the lease, and the tenant should have that because that's a requirement if that lease is in writing. And whatever other documentation the tenant has, we want to see that. So if there's email communications back and forth, even text messaging that can be screenshotted into pictures, give us, all of that can be uploaded as part of the complaints. We want to take a look at all of that to give us the most amount of information so that we can mediate it properly. We've got some resources online. So if you go to our website, datcp.wi.gov, there's a whole bunch of fact sheets that we produce. We probably have over 100 or 200 fact sheets, but there's a couple of them specific to landlord-tenant law. Our landlord-tenant guide is very popular, and tenants' rights and responsibilities. And then, of course, the copies of the laws if you're into reading law, or maybe you just can't sleep at night, I don't know. But that's available as well. And then lastly, just how to file a complaint with us. Easiest way is right through our website. I'll kind of walk you through that process. This is what our homepage looks like. You just click on the consumer side of the website, click on file a complaint, click on consumer protection. I didn't design the website. It's a lot of clicks to get there, but once you click on that, you get to our page where you can file a consumer complaint, and there's one specifically that says landlord-tenant practices. Or that one right there that just says general consumer complaint online, click here, it's fine. Even if you click the wrong one, don't worry about it. All the complaints go to the same place, and we can change that on our end and get it assigned to the correct mediator. And it's just a simple online form to fill out. It's your information, as much information as you know about the business, or in this case, the landlord. There's a question of what you would like to see as a result of the complaint. What are you looking for? There's a narrative box where you can type up everything that's going on. And then once you submit the complaint, you can submit those other documents like the lease or copies of emails, text messaging to give us whatever other relevant information you have. If you don't have access to a computer or the internet, just call our 1-800 number and we'll mail you the complaint form, we'll email it to you, we can fax it to you. However we can get a complaint form in your hands or in a tenant's hands, get that filled out, get it back to us, we'll get that in our system and start mediating that and start looking into that for the consumer. There's my information. There's that 1-800 number that I talked about right there. And so that's the easiest way to just get a hold of somebody, and we'll just send out the complaint form or answer questions online for you. All right, and with that, I'm going to hand it over to Matt.
Thank you.
Thank you.
Make sure that my mic's on here. It is, all right. I'm Matt White. I am the Bureau Director for the Investigations Bureau of the Equal Rights Division. We enforce only 40 laws compared to their 70 laws, 40 some. But that includes housing discrimination, employment discrimination, discrimination in public accommodations, and all of your sort of wage and hour, child labor, minimum wage, that's all enforced through our division.
Sorry, man. I'm
Yeah.
not sure that you're on.
The green light was on? Oh, yeah, it's still on. What did I do? Now I broke this.
Okay, now I hear you.
So, you're all right? Okay, good. Sorry. Oh yeah, there it is. I can hear it now. Everybody hear me okay? I also, my dad was a preacher, so I'll use my preacher voice if I have to. Don't make me. My preference as I go through this presentation is that if you have questions about anything that I'm talking about, just jump in, shout your question out. I'll probably repeat it to make sure it feeds through the microphone system. And I'm happy to answer them that way. And then that way, there's plenty here to talk about, and I could just read the slides to you, but it'd be more interesting if there's something you're interested in, if I can help engage by answering your questions. So do stop me if you'd like me to. This is just a little roadmap of what I'm going to talk about. We are going to talk about the Wisconsin Open Housing Law, what bases are protected under the law, what actions are prohibited, and some specific rules or exceptions, particularly, we still having problems?
You're cutting in and out, so I'm just going to, if you don't mind, I'll hand you.
I do not mind. I will use this and
Give me yours.
take this one up.
Sorry about that, everyone.
Everybody hear me okay? Yeah. All right, I feel like a bad stand-up comic, and the Catskills like, is this thing on? So we will talk about some specific rules and exceptions, particularly related to reasonable accommodations if you have a disability, and some issues that have come up related to victims of domestic abuse or stalking, which is a protected characteristic under here. And then I have some resources and community organizations, and once again, if you have questions throughout this, please stop me. So the open housing law makes it unlawful to discriminate against someone in housing based on their protected characteristics, which are these. So a lot of them are sort of self-explanatory, you know, sex, race, color, disability, religion, the same things that you would see in employment discrimination, but there are also some bases here that are maybe less obvious. So marital status is the status of being, it's not specifically who you're married to, which is a popular misconception that we deal with. It is the status of being married, single, separated, or divorced. It's unlawful to discriminate on the basis of that status. If the landlord is discriminating against someone because they don't like who the person's particular spouse is, that is not a violation of the housing law. You know, as I say frequently when I'm talking about discrimination issues, the discrimination has to be because of something that's covered by one of these protected bases. If someone is kind of an equal opportunity jerk, right, they're mean to everybody, that's not unlawful, as much as it seems like it should be. Family status refers specifically to whether you have children or how the size of your family, subject to reasonable occupancy limits. So if you are a family with, you know, 2 parents and 8 kids, the landlord can say there's a local ordinance that says you can only have this many people in this apartment, and that's not discriminatory. But a landlord cannot say you cannot have kids in our apartment complex unless it's like a senior apartment complex, which is one of the exceptions that we talk about. Status as a victim of domestic abuse, sexual assault, or stalking is protected. So you can't be evicted because your partner abuses you, or someone from work is stalking you, or something like that, and it causes a disruption in the rental complex. That is protected. Lawful source of income, pretty much what it sounds like, right? Although oddly, there is case law that says that Section 8 vouchers, which is a way of that the federal government helps people pay for housing, that's not included in that. But, for instance, if you are on Social Security payments, or you have SSDI because you've got a disability, those are lawful sources of income, and the landlord can't say, sorry, you don't have a job working at, you know, the Oscar Mayer plant, you have SSDI, so I'm not going to rent to you. That kind of thing is unlawful. And the last one I want to mention on here is age. When we talk about age discrimination in employment, which is what you're most likely familiar with if you know about age discrimination, we're talking about it's unlawful to discriminate against people who are over 40. In housing, it's 18 or over. So you can refuse to rent to a 16-year-old. That's the that's the takeaway there. Any questions about the protected bases? Any of these not clear to anyone? All right, I will go on, but again, stop me if you have a question. So, prohibited actions. The main one that we're concerned with today is refusing to rent. But just be aware that our law also covers sales of houses, or you know, if you're signing a contract to construct a house on a vacant lot that you own, that must be handled in a non-discriminatory manner under our law as well. The landlord may not charge more for against somebody who has a particular protected class. Sorry, it's late in the day here. So, you know, you can't set a differential rent of rate between tenants based on some characteristic that they have. That would be unlawful as well. Refusing to renew a lease is essentially the same as discriminating up front in housing. or causing the eviction. And then any discrimination in providing privileges, services, or facilities related to housing. So you can't offer amenities to certain tenants based on their membership or non-membership in a protected class. This all has to be sort of equal. Okay. So far, so good. I won't worry about this as much, but there is also a misrepresentation, same as in the consumer protection regulations. There's a misrepresentation prong of our open housing law, which says you can't falsely represent that housing is unavailable for rental based on someone's protected class. That will come up in a few slides. I'll just mention real briefly. Testing is the thing that happens, and this is the piece that sort of authorizes that. And then otherwise making unavailable or denying housing. The point of all this is these rules are incredibly broad. Okay, any way that a landlord might be trying to have different or disparate treatment of a tenant or a prospective tenant based on their protected class, it is probably unlawful to do it if it's because of that class. So, and you can see I pulled these slides from an old presentation on homelessness, which is not bad. But so, individuals with a disability. How do we define disability? Is that well, no, we're going to get to the what's prohibited. So a disability is a permanent physical or mental impairment that makes achievement unusually difficult. And a landlord may not do any of these things. And really, just if you're thinking back a couple slides, you can't make unavailable or deny housing on the basis of disability. That's the bottom line, right? So there are, I should say, a few things about disability law that are a little different from other areas. So the first one I want to mention is service animals and emotional support animals. You're probably all familiar with service animals. This is, like a seeing eye dog, or interestingly, in Wisconsin law, a seeing eye horse. Have you seen these online? You're in for a treat later on. Go home and go on YouTube and look up like seeing eye horses, because they're these little tiny ponies that lead. It's the cutest thing. They're covered by Wisconsin law, so recommend that to your blind friends, I guess. But a service animal is an animal that's been trained to perform a specific task or to do a specific job. So these are animals that have been very carefully trained. They often have a vest, although that's not required. And the task or job that they're trained to do is related to the disability. So this can be a seeing eye dog. Very common to have folks that have epilepsy or other seizure disorders. They can train dogs that the dog will know the person is about to have a seizure before the person knows they're about to have a seizure. So the dog will indicate, and the person can summon medical assistance, prior to being unable to do so. And they even have them for depression or anxiety, or even cancer, which is weird. But the key here is that the animal is specifically trained to do a specific task under a specific circumstance that's related to the disability. That's a service animal, and it is more highly protected than our second category here, which is what are known as emotional support animals. Emotional support animals are not necessarily trained to perform a task. They're the kind of, I have a really sweet kitty, and when I get sad, I snuggle with the kitty because it's warm and soft and it makes me happy. That's an emotional support animal. And I'm not minimizing. That's actually a true thing about kitties. They're soft and warm, and you can cuddle them. So you all can say you learned that today. But when you're talking about if you have a disability, for instance, if the reason I have an emotional support kitty is because I have major depressive disorder, and I need this animal for emotional support, it has not been trained to perform a task. Instead, it is just an animal that my doctor has told, in this case my landlord, but also potentially in some cases an employer, if we're talking about employment. The doctor has said this person needs this animal as a reasonable accommodation of their disability, which reasonable accommodation, I think, is the next slide. No, it's not. Wah, wah. So reasonable accommodation, if you're not familiar with the concept, is in the disability discrimination world. It's when, in the case of housing, a landlord makes a change to the premises or the terms or conditions of a lease to allow a disabled tenant to enjoy their tenancy on the same or equivalent terms as someone who doesn't have a disability. So in housing, it is often the case where when we're talking about modifications to a property, if you're renting, reasonable accommodations typically they have to be offered if they're needed, but they're often at the tenant's expense. So if you are renting a house rather than an apartment, for instance, and you are wheelchair bound, and you need a ramp installed, and the house doesn't have a ramp, if you rent the place and you need this ramp, and there's no other less restrictive way to make the house accessible to you in your wheelchair, you are permitted to install a ramp, but it's at your expense. The landlord doesn't have to do that necessarily as part of the agreement. When we're talking about emotional support animals, the analysis is first of all, whether the person actually has a disability. So there's probably some medical proof element involved. I would tell my landlord, I know that there's a no pets clause in my lease, but my doctor says I need an emotional support animal for my major depressive disorder. Here's a note from my doctor that says this. And then, the landlord may charge me a $50 pet rent deposit or something like that. There may be some negotiation that takes place in terms of setting the terms. And we won't open the Pandora's box of the issue of whether or not we can modify the lease in the middle for this purpose. The reasonable accommodation process is often sort of a negotiation, and it's always fact intensive, right? So we're going to look at what is the disability that the person has, what are their needs for an accommodation, is there a less restrictive accommodation? So, with our wheelchair example, suppose that there's a back door and a front door to the place, and making a modification to the front side of the building is going to really affect the property value because it's the house abuts the sidewalk pretty close, and this ramp is going to be right up against the sidewalk. It's going to be really ugly. It's going to hurt the property value, but it's also feasible to put the ramp in the back, where you get out of the car. When we're talking about a reasonable accommodation, the tenant who needs the ramp may talk to the landlord and say, I need a ramp, for wheelchair accessibility. And here's my plan. I'm going to put it in the front yard, blah, 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 blah. And if the landlord says, well, that's really going to hurt the property value, I would like you to put it in back instead. The analysis then is whether or not that alternate accommodation effectuates the intent of accommodating the tenant. So, if the person is able to use the house with a backdoor ramp, then the landlord may be able to require them to put it in the back instead. So that's sort of the takeaway, is that these are fact-based inquiries they're very dependent on the circumstances, and there's no, almost never in disability law is there a clear-cut answer about whether or not a particular accommodation is required. It's always what the lawyers call interactive process, but what it really means is we're having a conversation, right? You're saying, this is the accommodation I need, and I'm your landlord, and I'm saying, you can't have that, but you can have this other thing that'll work. And we're going to go back. And then ultimately, the question of whether or not that complies with the law is, if the person ends up filing a complaint and we end up looking at it. But, in most cases, these things can be worked out, and that's the goal of the law. Any questions about disability? Disability discrimination is like its own whole lecture, which we won't, fortunately, do tonight.
Can I ask what type of proof are they going to ask for? If somebody says, my dog, this is my emotional support dog.
Sure. So the question is, what kind of proof might be required if we're talking about an emotional support animal? And typically, the person has to demonstrate that they have a disability, which, and I rattled it off real fast, but I'll repeat it. A disability is typically a permanent physical or mental impairment that makes achievement unusually difficult. That's how it's defined in the Wisconsin Open Housing Law. So under the Americans with Disabilities Act, which is similar, disability is a permanent physical or mental impairment that substantially interferes with one or more major life activities. Either one of those basically means, does it substantially interfere with your ability to enjoy your life? And that can be anything from I have a back condition where I'm in a lot of pain if I drive a car. I can't pick up physically pick up my kid after school because I'm injured. I can't grocery shop for myself. Someone has to help me do that. Or I can't sleep through the night. It could be any sort of situation that I have this permanent impairment, and it makes these ordinary life activities just too difficult. So first of all, that's the first step. The doctor has to say, Matt has major depressive disorder. It's characterized by these symptoms, and I am not a clinical psychologist, so I can't tell you the exact symptoms, but you get the idea. And it's severe, and he needs assistance. So the landlord is permitted to ask for medical documentation, at least to the extent necessary to establish that it is a serious enough condition to be a disability. So there's that bit of proof. And then, because we're talking about emotional support animals, we are also going to look at whether or not the doctor who diagnosed the person with the major depressive disorder is going to then also say he needs an animal, a dog or a cat or whatever animal, because it will give him emotional comfort. It will aid him with dealing with his depression by X, Y, and Z, and they'll spell it out. Do not believe the claims where you can go on Amazon and buy a little collar that says emotional support animal for $10. This was a thing that was a big deal a couple years ago, kind of pre-pandemic, because people wanted to take their animals on airplanes, and there was this idea going around that if you had this emotional support animal collar, the airplane could not refuse to let your animal on the plane, which was not true then and is not true now. The ultimate inquiry is whether you have the disabling condition that counts as a disability, and whether the doctor says that the animal is a necessary and reasonable accommodation for you to be able to enjoy the privileges and benefits of your tenancy. Does that answer your question? Great. So lawful source of income. I sort of mentioned this in the bases screen, but it's unlawful to discriminate against someone because of where their money's coming from. And Section 8 rental assistance is not a lawful source of income under the Act. That's bad case law, and I don't like it. But sometimes when we're dealing with these discrimination laws, the way that the process works, and we'll talk about the process in a couple minutes, but it eventually can wind up in the courts, and the judges are not necessarily experts on applying these things, and so they'll interpret the law in a way that we don't necessarily agree with, and then we're kind of stuck with it. So, victim status. So it's unlawful to discriminate against someone because they are the victim of domestic abuse, sexual assault, stalking. And I wanted to point out these last 2 points. This is one of those special cases that's been coming up lately in the news. And you may have seen it, especially, it's been happening a lot in the Milwaukee area, but it is spreading. And what is happening is certain police departments, and I don't know locally if this is an issue, but certain police departments, if there are a certain number of 911 calls to a particular apartment complex or to a particular home, they will charge the property owner a nuisance fee. Essentially, there's a fine that goes to the property owner because these emergency services are called out so frequently to that location. And then, the landlord is getting charged, and they want that tenant out because whatever the reason why it is. And in the instance that there's it's because there's noise violations over and over again, there's nothing discriminatory about it. You still have to go through the eviction process in the small claims court, just like Jeff talked about. But when the reason that the police keep getting called out is because, a couple broke up and because of abuse, and the partner who was kicked out of the apartment keeps coming back and trying to break into the apartment, and the person who's still living there keeps calling the police because they're in danger. The landlord cannot use that nuisance fine as a justification for an eviction action without violating the open housing law, because the reason the police are getting called is because of the status of the person living there as a victim of domestic abuse, sexual assault, or stalking. Unclear kind of where that leaves the landlord. It's kind of a catch-22 for them because they're getting charged. They probably could, and this is just my lawyer brain wanting to solve problems, they probably could go to court and challenge the fines that the municipality is levying against them, saying it's a domestic abuse situation and we legally can't take action to stop them from calling the police under those circumstances. I don't know. That hasn't come before us, but the issue of whether or not these nuisance fees are legal, it's pretty clearly no under our law, and it's something we're watching. So landlords and rental companies can discriminate against someone for not being 18 years or older. I'm not going to worry about the homeless stuff right now. Testing. Testing, you may have, if you've seen any like 60 Minutes documentaries or any of that kind of interesting stuff about this subject area, testing is when we think a landlord is discriminating on the basis of race, or more recently we've had some testing cases with the sexual orientation of the tenants. And what we do, primarily through a partnership with the Milwaukee Metropolitan Fair Housing Council, which despite its name is a statewide organization, but they send out testers. So how that works is, if we think they're discriminating against black tenants, for instance, in a particular apartment complex, they send me out with my white partner, and we go out and we have fake resumes made up or fake documentation that says our salary is X amount of dollars, and here's the number of people moving in, and here's sort of all the facts. And then they find another black couple who has very similar, they create very similar qualifications for them in terms of salary, in terms of move-in date and all that sort of thing. And they have a phone in their pocket because Wisconsin is a one-party recording state, and they go in and they are recording the interaction. And if the landlord is willing to rent to me and my partner, but then the black couple comes in and they're like, I'm sorry, we don't have anything available, that's a testing claim then, because they, very similar, nearly identical couples. The only difference is the race composition of the couple, and therefore we draw the inference that it's based on race. We've been doing some of these lately with, as I referenced, sexual orientation. You have a couple with two women come in, and then you have an apparently cis hetero couple come in, and if the terms or conditions of rental are different, or rental is not available to the same-sex couple, then that is unlawful. So it's one way that we are able to pursue these things. The Equal Rights Division is actually empowered by law to perform this testing ourselves, but we're not funded to do that, so we do it through partnership with local organizations. That ends up being a weakness of the rule. Any questions about testing? It's kind of interesting, but it's not necessarily the most relevant thing to folks that are interested in their own landlord-tenant issues. And then I just want to talk briefly about remedies and about our process here. So this has changed a little bit, and it's, I think, in an interesting way. As you know, in 2018, not only did we get a new governor, but we also got a new attorney general. And there was a change in sort of enforcement priorities in the Department of Justice. And I'm not here to editorialize about whether it's a good thing or not, but I will tell you some exciting things happened in the open housing law with the change of administration, which is for the first time in 20 years under either party's administration. The Department of Justice is interested in getting involved in these housing cases as they're authorized to do by statute. Neither type of administration up until this current one had done that. So when there's an eviction action that starts to take place, if the tenant believes that the reason they're being evicted is because of their membership in some protected class, they can contact our division, and as part of filing their housing complaint, they can let us know, here's the eviction papers that we were given. And we actually can and have gone to the Department of Justice, and then we have a lawyer from the DOJ go into a court and get a restraining order that says that eviction action cannot proceed until the Equal Rights Division has concluded its investigation of whether there's discrimination in housing. Why does the statute authorize that? Because if a landlord is permitted to evict someone for a discriminatory purpose, once they're evicted, there's very little that we can do to help them, right? They're already out of the housing. We can't, some other family has moved into the apartment that they were kicked out of. We can't then kick some innocent family out just because there was discrimination in the prior tenancy. So we have the power to preserve the tenancy until such time as we figure it out. The vast majority of the time, the Department of Justice contacts the landlord and they go, oh, that's okay, we'll hold off on the eviction. We don't want to get sued by the Department of Justice because that shows up on CCAP, and landlords don't want their names on CCAP being sued any more than anybody else does. So that usually, slows the train down and lets us have time to investigate. There are damages available, economic and non-economic. non-economic meaning, economic would be compensatory damages, like if I am evicted for a discriminatory reason and I have to incur emergency moving expenses. So the movers, because I had to get them in one weekend, it was $1,000 or something like that. If I win my discrimination case and I shouldn't have been evicted, the landlord may be on the hook for those moving fees because they caused them. Non-economic damages would be like potentially pain and suffering, those kind of things where, I'm impacted. Only a court can award those. And we also have forfeitures, which are fines. We can impose fines on landlords that violate the open tenant law, as well as if a tenant is represented by an attorney and they win, the landlord has to pay their attorney's fees as well as the landlord's attorney's fees. The other thing the Department of Justice has started to do that they're authorized to do under statute that they've never done before is in cases where we find probable cause that there is some reason to believe discrimination has occurred, they actually can represent the complainant either in an administrative proceeding before our agency or in court, which again, I don't envy the landlord who has to have the Department of Justice, opposing them in court. I once had a teacher in law school who was a U.S. attorney, and he said that it's like the best thing in the world to go into court and be like, my name is Joe Smith and I represent the United States of America. Like, it's a huge push, and it's the same thing with the Department of Justice. I'm Assistant Attorney General so-and-so. I represent the Wisconsin State Department of Justice in the state of Wisconsin, and I'm here to say this landlord is, it's not something that you want typically as a landlord. So our posture as an agency, the Equal Rights Division, is a little bit different with these housing cases than it is in other areas. In most areas, we are like consumer protection in that we are an agency that is a neutral fact finder, and we mediate cases, and we have administrative law judges that decide whether there's a violation. Housing is one of the very few areas where we are also a prosecutorial agency. So if we find that there's a violation and we get Department of Justice to agree, which we often do, we will take the landlord to court and prosecute the housing case because it is there's obviously, I think, a severe power imbalance between especially large institutional landlords and a pro se tenant. So the state has the ability to step in those cases, particularly if it's either egregious or there's a lot of damages. The Department of Justice will step in and help with that. Any questions about that? Yeah.
Can a landlord break your lease or evict a person for no reason?
They can, subject to, I'm sorry, let me repeat the question. Can a landlord break the lease or evict a person for no reason? Subject to the protections for consumer protection, which they can't break it during the lease, right? They have to follow the lease termination procedures and the eviction procedures in the courts, the same as anybody else. But if they do all that and it's not because of protected class, they just don't like you personally or something like that, then they can legally do that. However, in discrimination cases, in really any kind of discrimination case, but housing is no exception, it's very, very rare that we get what we call direct evidence. Direct evidence of discrimination would be, I'm going to kick you out of your apartment because of your race. I don't like people of your race, and they tell you, right? So rare that actually happens because, even if that's what they're thinking, they're not going to say it. And in the vast majority of discrimination cases, I don't even think that the party that's being accused of discrimination, I don't even think their thoughts are that overt. There's just there's cultural differences or things like that, and they don't even realize that they're being motivated by some protected characteristic. So the vast majority of cases, over 90%, are proved through what we call indirect evidence, which is we look at all the facts and circumstances that surround something and we try to construct an inference that we believe discrimination is the reason. And that's a great example of that is testing, because the majority of testing cases, the gay couple comes in and gets denied an apartment and the straight couple comes in and gets offered an apartment, but the landlord doesn't say it's because this couple's gay, we don't rent to gay people. But that's a super strong inference that it's based on their sexual orientation, because we know we've carefully constructed this scenario so that everything else is equal. The only thing that's different is that sexual orientation. And so that's an indirect evidence case. It's a little trickier with something like discriminatory eviction, right? Because we're not having a testing case. We can't eliminate all the variables. But still, we're going to look at all the tenants in this building. Were any other tenants evicted or non-renewed? were any other tenants in a similar position to the people that were evicted with respect to whatever the landlord's stated reason is. So they were behind, they constantly paid rent late, and that's why we evicted them. Did anyone else in that building pay rent late? What was their race? What was their sex? And so forth. And so we tried to gather the facts and then eliminate anything that's not a discriminatory motive by comparing those facts with other people outside the protected class. It's very difficult. Okay, for plaintiffs in any kind of discrimination suit, it's very difficult to prove this because essentially it's a kind of telepathy, right? You have to like figure out what's going on in somebody's head, and they're not going to tell you, so you have to deduce it, like Sherlock Holmes or something. Which is why it's fun, in my opinion. But that, it's not fun for the people that are having to prove it. Does that answer your question? I love to go on tangents, which are not necessarily related. Was there a hand over there?
I was just going to ask, can you share, like, well, how do you prove that? That if I'm an 80-year-old and I think that you're not going to renew my lease because I'm 80, or maybe because the ambulance comes all the time since I have health issues, how do I prove that? And by the way, I don't have a computer, so I can't, do my email trail.
Right.
I don't know that technology. How do you prove that?
Well, I mean, if somebody were to call our agency and ask, how do I prove this? I think this is going to happen, and how do I prove it, right? We would tell them the same thing that Consumer Protection would tell them is document, document, document. Make sure you get dates. You write down the details of conversations. If you do get emails or text messages or phone pictures or whatever, you save them. And even in cases where something's very egregious, we recommend that because, any legal proceeding can drag on for a year or two, and what's going to happen is 2 years down the line, you're going to sit down on the witness stand, and the landlord's attorney is going to make a lot of hay over the fact that you can't remember the specific details. Like, maybe you're not telling the truth. You can't tell me what exactly he said or when he said it, and that documentation is a way to refresh your recollection. So we would advise people to make sure to keep all of that. And we too have been deluged with camera phone pictures and things like that, snapped of things that were taped on doors, or screen captures of text message exchanges with landlords or that kind of thing. And we see that in really all of our kind of discrimination cases. But then once you get past that, the documentation, and you're actually into the process of proving it, again, your classic discrimination claim has a few elements. The person who's filing the complaint is a member of a protected class, so I'm going to say, I am a person with a disability. That's my protected class. Then you're going to allege that there's an adverse action. So the adverse action is I was evicted or I was non-renewed on my lease. That's the adverse action. And then the third prong is the connection between those two, which is I think that the reason I had the adverse action was because of my disability. And that one is the one that's hard to prove, obviously. It's I can get a letter from my doctor documenting my disability. Obviously, if I was evicted, there's court records. The question is, how do I connect those up? And like I was alluding to earlier, what we're going to look at is the landlord will state whatever they believe their non-discriminatory reason is for non-renewing. We didn't renew them because we want this, and this is from an actual case that came up recently that went to the DOJ. We non-renewed them because we just bought this property. It was like not a duplex, but I don't know if they call them a triplex, but like a house with 3 units, right? And we non-renewed this one family from the units because this place that we just bought really needs to be remodeled, and we can't do the remodeling while the people are in the place. And so these people were forced to move out so the landlord could remodel, but they filed a complaint with us, and lo and behold, the landlord had non-renewed, I think it was a Latino family, and basically kicked them out of their housing so they could remodel, but the other 2 units were occupied by white families and they were not non-renewed and they were allowed to stay. And that's an awfully suspicious circumstance, right? Is it 100% ironclad, as good as if the landlord had said, I don't want to rent to Latino families, it's too big of a family size, whatever the protected characteristic is? No, it's not as good as that direct evidence. But what we're going to do in the investigation process, my staff will do, is they will gather all that information and they will try to use the other families that were not non-renewed as a comparator. So they'll look at them, they'll look at their circumstances and the circumstances of the family that was evicted, and they will compare them and try to eliminate all the factors that the landlord states are the legitimate reasons. And if they can do that, then they can demonstrate that there's reason to believe discrimination occurred. Does that make sense? It's a super interesting area of law. I wish I wish I had like all night to talk about it. You probably don't wish that, but you know, yeah.
When you sign a rental agreement, the landlord can say if there's any problems between, two entities that you are going to pay all their legal fees, and if you win, you're not going to charge them for your attorneys. Can they do that?
They cannot. No, they cannot. So first of all, I think Jeff was saying that you can't have a fee shifting provision in a lease. So the landlord can't say, if there's a dispute about this lease, you'll pay our fees. And I think it's also illegal to have what they call liquidated damages fees in there too. So they can't charge tenants for the landlord cannot charge the tenant for their attorney. No, is my understanding.
No, that's one of those situations where that if that language is in the lease, that could make the entire lease null and void.
Right, and the attorney fee provision for tenants on the other side is in the open housing law, and that also cannot be waived in the lease. So the landlord cannot say, if there's discrimination litigation arising out of this lease, both parties will pay their own attorney's fees. They can't invalidate our discrimination law by contract. They're just not allowed to do that. So, go ahead, yeah.
So you go in to pay your rent one day, and this company had just bought the company that I rent from. By the way, you didn't pay your rent on time a year and a half ago. You want some extra $50. Really? If I haven't paid my rent on time, they didn't tell me in a year and a half. How do I prove that a year and a half later?
So the question is, new landlord comes in, purchases a property that you've been renting from for a while, and then you go in to pay your rent, and they say, a year and a half ago, the previous landlord, you paid your rent late, you owe us $50.
Or they might have bought it by then, I don't remember.
Or they might have been the owner by then. I don't know that sounds in discrimination. I don't know that it's a discrimination claim unless I don't know. I would say it's probably not legal, but that's not really a discrimination question. I'd defer to Jeff on that one.
Isn't there some time limit then to inform you paid your rent?
Yeah, that doesn't sound right to me either. I would say in that situation, file a complaint with us, and we'd be happy to take a look at that. If it was late rent from a previous landlord, once the new landlord comes in, there would be new rental agreements. So I don't know how the new landlord would be able to go back to that previous one. And even if it was the same landlord, I don't know that law off the top of my head, but I would imagine something 18 months old is probably too old to look into, but we'd have to look into it.
Mail your rent in, you have no proof whether that got your rent.
So so at the beginning of my presentation, that was why that one provision is in there, that if you pay rent in cash, or you pay any money that's paid in cash, the landlord has to provide.
They don't allow cash.
Okay, how do you pay?
Just to get an envelope and rent.
A personal check, or okay, so you could potentially get a copy of that check from your bank.
You see, when they cashed it, yeah, and I thought of that. But what if they hold it? They can hold it for 3 days, throw the envelope away with the postmark on it, say this was late. There's no way to prove it. That's scandalous.
Yeah, there's probably a way to track that down. If the landlord is saying that a year ago May you were late on rent, your bank probably still has an electronic copy of that check, and the bank would be able to see if that check was cashed, which would.
They hold the check in their hand and do not go to the bank and cash it. Say, this came right just because you dated it on the 27th. That doesn't.
So I'm gonna kind of paraphrase your questions just so the folks on the microphone can hear what you're saying. How do you know if a landlord doesn't cash the check right away? What if they get your check in the mail and they just hold it for a week, so then they can turn around and charge you a late fee even though you weren't late? Is basically the question that Jeff's been answering here. So I'll kick it back to you.
Yeah, I should have been repeating that. Sorry. As the tenant, I don't think it's your responsibility that the landlord cashes the check on time. If they cashed it late, I would imagine they would go by the date that was on the check. But again, if they're trying to hold you to some kind of late fee and you don't think it's right, just file a complaint with us, and we'll reach out to the landlord and get their side of it and go from there.
Oh no, got a question back here.
Doing it again, I'm not going to tell them.
What if the lease is 80 to 100 sheets of paper long, and they keep doing this to you?
what if the lease is 80 to 100 pages long and they keep doing this to you?
Well, that would be a new one. I don't know if I've seen a lease that long. I'd probably have to get a lawyer friend of mine to read through that one.
I was married to a different race many years ago, and my children are of two different races. I've also been in prison. So I know what litigation looks like, and I swear that the lease was this thick. And I know when you're trying to harass and abuse.
Yeah. So he was just saying he had some familiarity with litigation, and the thing was really thick, and he can tell when they're trying to abuse. As an attorney, not your attorney, by the way, I can't give you legal advice, but I can tell you that ambiguities in a contract, when a contract is not clear about something, they're generally, the court will interpret the contract in a way that goes against the person who drafted the ambiguous part of the contract. If I'm advising a landlord, I would tell them not to have a 100-page lease, because if they screw something up in there and you sign it and then it's unclear, it's going to be interpreted against them because they did not make it clear. There's no reason for it to be that long, right?
What about identification of the tenant? They have my bank account numbers, they have every kind of information on me you could possibly imagine.
So what about what we would call in the state government business personally identifiable information, PII, that the landlord has? And I will kick that to you.
Yeah, I can take that one. I mean, just like lots of other businesses out there that have our personally identifiable information, if your question is if they intentionally use that against you, that could be identity theft. That's a criminal violation. That's a Class H felony in Wisconsin. If they don't keep your personally identifiable information safe, that could be considered a data breach. They would have to make a notification to you if somebody, an unauthorized person, accessed your information. Does that kind of cover your concerns about your information being out there?
Yeah, well, I know my information is out there, and I know my emails are being hacked also. And I know it comes from that very thick book.
Yeah, I would say come to one of my other identity theft presentations, and we'll talk all about data breaches and personally identifiable information. There's lots of ways that can be used against us, but you're correct. When you apply to rent an apartment, Social Security number is usually on that application, a lot of personally identifiable information, and we're just at the mercy of that business, or in this case, the landlord, to keep that information secure and private and only use it for what they're supposed to be using it for. If they do something other than that, that's a huge violation. That could even be a criminal violation.
And I'll add to that, if the reason they're doing that is to harass you because of some membership in a protected class, that also would violate the open housing law. You can't harass someone because of some membership they have in a protected class. So if they're using your PII inappropriately to harass you, and it's because because of the race of your spouse or because something like that, then that would be unlawful. So, great questions. Any more questions here? I think I might have a slide or two more. Yeah, go ahead.
This is kind of like the annual lease or a one-year lease, and let's say, there's a couple, and then they're elderly couple, and then one dies, but the person left can't really take care of themselves. Do you have to go through the whole year then, or do you just ask for mercy, or do you have a tough situation? Or?
So the question relates to, and tell me if I'm not paraphrasing this right, relates to an elderly couple. One of them dies, the other one can't really take care of themselves, and do they have to go through the rest of the lease, or just sort of throw themselves on the mercy of the landlord? And I will once again.
Yeah, sometimes there's wording in leases that would allow somebody to, like move into an assisted living facility, like in the middle of a lease. But I mean, ultimately, if the landlord doesn't agree to it and can't re-rent that apartment to somebody else, for the remainder of that year-long residential contract, the renter would be on the hook for that rent. But a lot of times in those situations, you can come up with something mutually agreed upon.
Great questions, everybody. Thank you. Oh, one over here, right behind me. Yeah.
Sorry about that.
No worries.
Before, you mentioned some fact sheets from the Bureau of Consumer Protection. Are there any specific ones that list some of the illegal, kind of a list of what a landlord cannot do or can do? The rights and responsibilities thing.
Yeah, there's two main ones that we offer. Our landlord tenant guide, which is like a 7 or 8 page document that'll list off a lot of the information that was in my presentation, and then tenants' rights and responsibilities. And if you can't navigate the website to find those on your own, just simply call that 1-800 number and we can just email them to you or point you in the right direction.
And I'll mention too that the Equal Rights Division website, you also can file an open housing complaint online through our website. If you go to the Equal Rights Division page, it's right on the front page there. And we also have resources that are available, fact sheets about open housing law, and even, I think, a couple of 60-second videos in our video library that address specific topics. So if that's something that interests you, please feel free to check that out. I'm going to skim through a little bit here. Okay. I mentioned the Milwaukee Metropolitan Fair Housing Council. I also want to mention a great resource, the Statewide Tenant Resource Center, who also has some great fact sheets on landlord-tenant law that are available, and landlord rights responsibilities, which I think a lot of it is probably drawn from the consumer protection folks, but also they have a lot of resources and FAQs and things like that. The 211 call center, I don't know if everybody's aware of that. If you dial 211 on your phone in Wisconsin, you'll get like a local service organization. It's oftentimes coordinated through United Way or similar groups, and they will connect you with resources if you are experiencing difficulties with housing or with hunger or any kind of social issue there. And then Disability Rights Wisconsin, if you're specifically looking for assistance with reasonable accommodations or with getting a diagnosis of disability, they will advocate on behalf of individuals with disabilities. So that's a really good resource that's out there. And here's my contact information. I welcome your emails and phone calls if you have questions about this stuff. I also, the Equal Rights Division, my staff is available during regular business hours to answer questions every single day. You're always welcome to call and talk through a situation with one of our investigators and see, whether or not there is a housing discrimination issue. They can send you a complaint form in the mail or direct you to the online system, or they can refer you out to other resources like consumer protection, like disability rights, things like that. So, any other questions we can answer for you? Yeah, great.
Security deposits. Say you're on a yearly lease, the rent goes up every year, you sign a new lease. Can the landlord match another security deposit to meet that raise in rent?
So the question is, when you have over the course of several years, you have successive leases with the same landlord and the rent increases, can the landlord charge a full additional security deposit or just the incremental difference between?
Like say you move in, usually it's the first month's rent security deposit. Rent was $800, you pay the $800 security deposit. Now can the landlord raise that security deposit throughout the years you live there?
Right, so can the landlord raise the security deposit in subsequent years? And I don't see any reason why they couldn't, right? They wouldn't be able to collect a full additional security deposit. So if your first year rent is $800 and they raise it to $850 your second year, they can't charge you $850 more for a security deposit because they're still holding $800 from the first year. But I would think they could probably ask for the difference, but I'll let you.
Yeah, they would not be able to do anything in the middle of the lease, but then once that lease ends and now you're entering into basically another new agreement, generally security deposits are equal to 1 month's rent, but there's nothing in the law that says it can't be more.
Right, or less.
Landlord can raise the security deposits pretty much as to what they feel they want to do.
Right, but in between lease periods only, they can raise the security deposit. Yep, they can't do it in the middle of a lease, just like they can't raise or change your rent or other terms or conditions of the rental. Yep.
And that would have to be disclosed to you before you sign the new lease. So then you have the option of either agreeing to that or not.
So security deposit is not a one-time charge then?
Does So the question is a security deposit not a one-time charge then? And I think it is a one-time charge, but the one-time is when you sign a lease. So when you are renewing a lease, you're effectively signing a new contract. Technically, I think probably what the court would say is happening if they raise your security deposit is that they're obligated to return your previous security deposit, and then you have to pay the full new security deposit. I don't know if any court is going to get that in the weeds with it, but that's probably legally what's happening. They might just say, you owe us $50 more for security deposit, and I honestly don't know how that would be handled. It does not come up much, I would be my guess. But
I would also agree that doesn't come up very often.
Well, you think it's a security deposit when you first move in, that's it. That's your security deposit. But then you sign a lease later and then they want another security deposit. It's like, well, I thought I already paid a security deposit.
right, so, and again, I would say if they're trying to charge you a full additional security deposit, there's probably a violation there of consumer protection regs that require them to return your previous security deposit within 21 days. They can't keep collecting a new security deposit and just sort of putting it in a bank account, because they are legally obligated to return that at the end of your tenancy if they don't need it to make repairs or whatever other non-ordinary wear and tear, right?
Right. So let's say I paid $800 the first year and I'm there 3 years and rent goes up $50, that would be next year, what, 150, so that'd be 950 towards my security deposit as a whole.
Right. So the rent goes up $50 a year, and the security deposit, if they are increasing the security deposit, the thing they can't do, I think what we're agreeing, the thing they can't do is say, first year you owe us $800, second year you owe us an additional $850, then an additional $900. Like they can't.
They can raise that deposit to match the rent.
They can probably. They generally, I mean, most landlords don't, I don't think, because it's just too much of a hassle. But I don't want to tell you they can't or that you'll never find that, because there are many weird things happening under the sun, and we can't we can't predict or control them, right? So.
And you would want to document all of that, so when it does come time to move out, you know how much
Oh, yeah, it's all on the lease.
you're looking to get back. Yep.
Great.
For January's rent, I usually pay that in the last months of December. So there's an ongoing dispute from year to year. Which month have I paid for? And I always document on the check what month it's for, and then I keep getting a dispute about how much I paid for the year, because we don't want to count the check that I wrote in December for January. And during the year, they change the amount. So again, there's a dispute about how much I paid for the year for the rent.
So the question is, pay the check in January, and there's a dispute because it was for December, and they're disputing whether or not you've paid the correct month's rent. And I'll just tell you, there's nothing magical about January 1st. You pay your monthly rent on a monthly basis, and when you pay it, and it's for satisfaction of the terms of the contract. They can't, I think Jeff's about to say, can't raise your rent in the middle of the lease, but yeah, that's not
On a year-long lease, or are you on a month-to-month? Yeah, if it's a year-long, they cannot change the terms of that contract unless you mutually agree upon it.
Technically, they reduce the rent a few dollars, and they do this every year.
So they reduce the rent a few dollars in the middle of the lease. Again, technically they can't do that unless both parties agree, but I guess if they're reducing your rent, sign off, right?
Gotta stack this thick about what I agreed to and what I didn't agree to.
So again, the 100-page lease, right? And if this were to ever go to court in a breach of contract or an eviction, the question is what you agreed to and what you signed off on. And they can't have you sign page 100 and then change pages 40 to 60 and not tell you. That still would not be legal. It would not be legal. No, you have to agree to the full terms of the contract, and they can't change them without you agreeing to the change.
But shouldn't there be a limitation as to how much is in this lease?
So the question is, shouldn't there be a limitation? And I think there probably should, but there isn't. So unless the legislature is to step in and change it, or there's some authority in one of our agencies laws to, to make additional regulations about that. In the absence of one of those things, it's not illegal to do that. So
It literally feels like I'm signing my life away when I did my lease.
yeah. Any thoughts?
Yeah, I'm also not aware of any laws that limit how long a lease can be. And then your other question about paying rent in December and they're not applying it to January, I also agree. I mean, there's a due date for rent, but there's no penalty for paying early.
Well, they do give me a benefit. They dispute what I paid for the year, for this example, and they've actually docked me $1 because they say I didn't pay any framework at the time.
Well, that's ridiculous. But
Yeah, and we're here if you want to file a complaint.
Yeah,
send us all that documentation. We'd be happy to take a look at it.
I'd encourage you to file a complaint. It's a weird situation for sure, and I would want them to look at it if it were me. So, yeah, a question back here.
Yeah, I lived in Nevada and I lived in West Virginia. In both those states, the landlord can only raise the rent a certain amount every year. What about the state of Wisconsin? Is there a limit the landlord can raise the rent, or is it unlimited?
So the question, she previously lived in, you said Nevada and West Virginia, and there was a limitation on how much you could raise the rent in a year. And is there any such limitation in Wisconsin? I don't believe there is, no.
There's not.
Yep, landlord can double your rent. Again, with respect to the open housing law, they can't do that in a discriminatory fashion, so they can't select particular tenants that they want to get rid of and then like raise their rent through the roof to make them leave. That's basically what we would call a constructive eviction. Constructive meaning they didn't actually go through the eviction process, but they made your tenancy so intolerable that you were forced to self-evict, basically. But that would only be unlawful if they're doing it because they're trying to get rid of someone, on the basis of their membership in one of those protected classes. If they're just doing it because they think they should get more for the apartment and they just want to charge more rent, that's not unlawful. Between lease periods, they can't. Of course, they can't change it in the middle. But they, when they renew, they can definitely make changes to the terms.
Okay, another one. On month to month, how many times can they raise the rent within every 3 months, every month if they wanted, every 6 months?
So I'll let you answer this. But the question is, month to month, Tennessee, how often can they raise the rent, say, in a year?
As long as they give proper 28-day notice. Theoretically, they could raise it every month.
And similarly, the tenant can leave whenever they want. Of course, in the real world, it's easier for a landlord to raise the rent than it is for somebody to uproot and find a new house, a new place to live, right? But that's the sort of symmetry of the month-to-month lease.
I've noticed this year they require me to pay online electronically. And, well, they don't require it technically, but they highly encourage it, especially when they charge me $1 for having that actual check. So the online cost me $2.95 for a transaction. So now that's an extra cost for me.
Well, that's an interesting question. The question is if they have an online portal for paying rent and there's a per transaction charge for paying the rent, is that an increase in rent that happens in the middle of the tenancy?
It is an interesting question. So there's a fee to pay online, or there's a fee if you don't pay online?
There's a fee to the company that does the billing, that handles the billing.
So the payment portal charges a fee that presumably doesn't go to the landlord, it just covers the cost of the transaction.
And if you choose to pay with a check, they charge you the $1 that you're talking, or?
Yes, so I've just started online paying. So they're charging me $2.95 to go online and do this. Sure.
So I believe the way the law is worded is that the landlord can decide how rent is going to be paid, but if there's an extra fee, that's definitely going to, like you said, that's almost a constructive increase in rent. So that would be something that we could look into as well.
Interesting. We got about 5 minutes left. Any last minute burning questions or? Like I said, both of our agencies are very, very available to the public, more than most agencies in the state, I would say. And if you have questions about these areas, please call us. This is what we are there for. And we're happy to talk to folks and talk through situations. And particularly if you get, with respect to Equal Rights Division, if you get in a situation with disability or with, victim of stalking or abuse, those kind of things that can be a little tricky, talk to an equal rights officer, see if they can help you out. Yeah.
Yeah, I agree. Give us a call. I mean, we might not know some of these answers off the top of our heads because look how complicated some of these questions can become, but we will find out the answer. We will research it. We'll get an answer for you.
So the folks who normally start with your office, they have an issue?
I would say it probably starts with us, and if it's a discrimination issue, we can forward it right over to.
Yep, those emails come directly to me, and I assign them to one of my investigators. When we get a consumer protection complaint and somebody mentions discrimination, I just get a copy of it. It comes to my email inbox, and I will have an investigator call you the same day usually. So might take some time for it to come between agencies, but once we get it, we'll get back to you right away.
Yeah, there's so many different state agencies out there that deal with some of these different issues, and we're really good at taking what we have authority over and then referring out to the correct agency, the other complaints.
Well, so I'm interested because I work for a resource center and we get a lot of calls about housing. And the tenant resource center hotline now is only focusing on Dane County because of funding issues. So finding somebody that we can send them to answer those questions because we can't legally provide, like you say, we're not lawyers, we can only share resources that we are aware of. And finding the right one, it's hard. We used to say, call the tenant resource center hotline. Well, now this is in Dane County, we can't do that anymore.
Yeah, we're also not lawyers, so we don't hand out legal advice, but we're a resource, and we have an entire book of resources numbers that we can hand out phone numbers to, depending on what the situation is.
And anybody who is a lawyer and tells you what to do and is not have a retainer agreement with you is not giving you legal advice either, because they can't unless that attorney-client relationship exists. So even though I'm an attorney and some of my staff are attorneys, we will talk through a situation with you and tell you whether we think you should file a complaint. We might refer you to other resources. What we will not do is tell you what you should do, because that would be unethical for us to do that. So
when they call and say, they're not renewing my lease, what should I do? That puts you in a tough spot. But you want to at least give them somewhere that maybe you could point them in the right direction. Right. So that's where we like to at least get something started somewhere.
Great, thank you. Thank you for that. We have about 2 minutes left, and I have a question in the back here. No, you're okay. You're great.
Okay, they say you sign a lease for 1 year. That year is up. It's 3 years down the line, and no lease or nothing, no mention month to month. And there's an issue starts coming up. Now, would everything go back to the lease?
So the question is, you sign a lease, you live there for a few years, even though you never really sign a lease renewal, and then a couple years later, issues start to come up. It doesn't say anything about month to month. I think the default is it converts to month, right? Because you can't have an automatic renewing 1 year lease.
Yeah, the default is it goes to a month, and then if an issue arises, you go back to that original lease for the wording.
You go back to it like 3 years?
Yep, even though that's now 3 years old, that's the last lease that was in place. The wording in that lease would potentially clear up what this dispute is.
Right, with the exception of any language in the lease that tells you when the lease ends, because it has converted to month. But if it's like how much you pay for your parking spot or something like that, and there's no new lease, then the old lease controls.
Okay.
Yep. Yeah.
So say I want out of my lease or to move, could I find somebody to rent my apartment and then still get my security deposit back, or would I lose the security deposit?
So the question is, if you want to move out early and you find someone else to rent the lease, which is called subletting, are you entitled to get your security deposit back, or do you just lose that?
I'm not sure. Because yeah, if you break a lease early, you're still responsible for that rent unless the landlord re-rents the apartment. But I'm not sure the landlord has to re-rent to the person that you choose. Has to go through their application process.
Right. Usually a lease has some provision in it about who you can sublet to, and that there's landlord approval, I'm thinking. With regards to the security deposit, it's going to be what you work out with the person you sublet to. So if they're going to pay a security deposit, then they'll be paying it to you, right? You paid $800 at the beginning of the lease. They're going to assume your lease for the last 6 months. So it's up to you whether to tell them, I need $800 from you for the security deposit, and then when there's a security deposit at the end, it will be reverted to you instead of to me. Or, you can sweeten the pot on a sublet by saying, I'm going to eat the security deposit cost, or you pay me half the security deposit, or whatever. Again, can't really give you legal advice, but it's all a matter of contract at that point, and depends on what's in the original lease and what's in the sublease. So, sorry if I stepped on your toes, but that's.
Oh, perfect.
Anyone else? All right, we're right at 7:30, so we'll wrap it up. I'm getting the high sign from the back, so thanks very much for coming, everybody. It was an interesting session. Great questions. Appreciate it.
Thank you.
Thank you.